before this court. Yes.
So, parties before this court, you have the three charged persons, Naitan,
Who is your client?
Yes.
Yes.
A husband and his two wives.
Yes.
Who are accused of child trafficking of a child.
They are accused, correct? They are accused. Are they children? All right. So, why do you want us to take this matter to the children's court, and yet your clients, they are not children in this circumstance of this case?
Your Honor, under Section 73, which says you allow me to read it. Your Honor, under Lordship, under Section 73,
Yes.
it establishes the jurisdiction of the children's court and states that there shall be courts to be known as children's court, constituted in accordance with the provisions of this section, the purpose for, to be specific, under C, hearing a charge against any person accused of an offense under this act.
Question, counsel. You said you're representing 3 persons. That is a husband and his 2 wives. And the question was posed to you, are they children? No, they're not.
This matter involves a child, and the child is the victim of this matter. So, we as the defense feel that this matter, if at all is taken to the children's court, this child, whom we as the counsels of the defense, we really care about the children, about their well-being. We feel that this matter, the children's court will be the appropriate forum to hear and determine this matter.
Counsel, if I may engage you a little bit, the jurisdictional mantle of a children's court involves situations where the child is the person who is the accused. Are you privy to that? The jurisdictional mantle, I don't know, Sauti. The jurisdictional mantle of a children's court extends only to matters in which it is the child who is the accused. In the facts at hand, and the reason why I'm headed to this is because the basis of your objection to the jurisdiction of this court is that it involves a child. But is the child the accused in this matter?
Our clients, they are any person as per the constitutional interpretation. Therefore, they qualify to be brought under children's courts. Actually, I was coming to highlight on that issue that you asked.
Counsel, now that you raised that question, we are talking about the probative value of if so to say, assume it's a probative value type of question, what's the status of a children's court? For example, when you read Article 162, Subarticle 2B of the Constitution of the Republic of Wilawa, which is similar in substance to the Constitution of the Republic of Kenya, it's specific that there are specialized courts. For example, we have the Land and the Environment Court, whose status is similar to that of a High Court. The question to me, to you, Counsel, is what status does a children's court have? And when it talks about its jurisdiction, does it talk of jurisdiction when a matter involves a child, or a matter in which it is the child who is the accused in this matter? Please respond to the two questions so that we conclude on the preliminary objection. Thank you.
Since the two questions are two-pronged, I'll touch on the first element and let me start because it was my element to handle. Yeah, because it's my element to handle, and the element I was handling is about the expansiveness of the jurisdiction of the children's court. He will talk about, he will explain everything else about the children's court. But on the jurisdiction, this court hears any charge against a child other than the charge of murder. I'm reading in verbatim from section 73B of the Children's Act. Meaning when a child is an accused, this court has jurisdiction to hear that case. Actually, it is well constituted to be the appropriate forum to hear such cases because they involve a child as an accused person. Then under 73C, when they hear a charge against any person accused of an offense under this act, if you have looked at the charges against our clients, they are under this act. Therefore, they qualify. This matter qualifies under the children's court because our clients have committed an offense under this act. Allegedly committed an offense under this act. That's why we are saying it's an appropriate forum. And so you will talk about the question from the children's court.
Counsel, your colleague avoided to address us to the Article 165. Could you please address us on that? Yes, of the Constitution.
Specifically,
subsection 3A.
He is coming to address that. And I'm limited to his speech.
Your Honor, Your Lordship, on matters of unlimited original jurisdiction, we as the defense feel that if this court, this high court, is used, if this provision of unlimited jurisdiction is interpreted in the sense that every matter has to be brought to this court, matters which can be handled by the lower court before they are brought to this court, the consequences are that we'll have cases, place, waiting, nature being brought to this court. The intention of the children's court being created was to ease the weight matters being brought to the high court, and also the unlimited to avoid the misuse of this position of the Constitution. So we as the defense implore this court to consider reverting this matter back to the children's court, which is the appropriate forum in which this matter involving a child will be handled.
Council, you talked about interpretation of Article 165. We asked a question on the basis of interpretation of Article 165.3. Yes. The question that I'm posing to you is just basically, what rule of interpretation did you subject that sub-article to for it to lead you to the conclusion that this court does not have jurisdiction, yet it's clear under 3A that it has unlimited, not just unlimited, but still original jurisdiction over all civil and criminal matters?
The crafters of this constitution did not intend that every matter, when they stated that High Court has unlimited original jurisdiction in criminal and civil matters, if you interpret this provision to say that every matter that is criminal in nature has to be brought to this court, then we'll be losing the ideal scenario in which the crafters of this constitution intended.
Okay, Council, you done with the issue? You done with your submissions on the same? Okay, we'll hear the other your colleagues and see.
Council, I like your presentation so far. You relied on the case of the estate of Minor, unless I'm wrong. You relied on a precedent, the case of the estate of Maina something? RNM. Could you maybe give us a brief statement of facts to that case and maybe the issues that were before the court for determination, and then give us the relevance of that case to the case at hand? Thank you.
Well, in this specific case, it was a children's matter that was moved from one court to another children's court. And here the issue was determining where there are two courts that have equal powers and a jurisdiction. How are you supposed to determine which court is supposed to handle the matter? For instance, in this case, the children's court has jurisdiction to handle children's matters. The High Court has unlimited original jurisdiction and inherent jurisdiction to handle every kind of children. So in essence, these two courts have equal jurisdiction. So how are you supposed to determine which court has jurisdiction over this matter? Now that the matter is already in this court, as per that ruling, the only peculiar circumstance that is supposed to be considered is the best interest of the child. Now my argument is this. Let's look at the implications of delay and transfer of this case from one court to another. Does this child whose rights have been violated over these years have that luxury of time to be jumping from one court to another? Now that we already established that this court has jurisdiction, I can state without any doubt that this matter has rightly been brought before this court, and we are able to proceed on this matter. I will also use the case of Peacock versus Bell and Kendall, and in this case it is stated, the rule of jurisdiction is that nothing shall be intended to be out of the jurisdiction of the superior court, but that which spatially appears to be so. And on the contrary, nothing shall be intended to be within the jurisdiction of an inferior court, but that which is so expressly alleged. The respondents were faced with only one issue of proving that the children's court exclusively and expressly excluded the High Court out of handling children's matters, but that has not been shown so far. So, in relation to Article 165(3) of the Constitution, read in Section 22 of the Children's Act, I put forth to this court that this court has jurisdiction to handle this matter as a children's matter.
Okay, counsel, maybe just one last question. The last case you mentioned, the court has not noted it well. Can you kindly repeat it? The last case, the case you've referenced.
Yeah, Peacock versus Bell and Kendall. Peacock versus Bell and Kendall.
Maybe is it a case within the jurisdiction or decided within the judicial system of the Republic of Laos?
This case was not expressly used in the Republic of Ulawa, but it has been adopted. The same holding has been adopted in the case of Samuel Kamau Masharia and another versus KCB Limited and two others, a 2012 case. And in that, they included also, as they took the ruling of the Supreme Court, they added that for the interest of justice, that is why we have Section 3A of the Civil Procedure Act in relation to jurisdiction where superior court has not been explicitly removed from a legislation.
All right, counsel. Now, just one last question before you sit. The question you brought, the case you brought before us, is it a criminal case, or a constitutional petition, or a civil case?
It's a
Constitutional petition. All right. Thank you. Give us 5 minutes to deliberate about jurisdiction, and then we'll give a ruling on the same. One, two, two. 1 2 1 2 1 2 1 2 1 2 1 2 1 2 2 1 2 1 2 1 2 1 Calling the court to order. I will ask the lead counsels to approach before we proceed. Lead counsels, have you deliberated? Counsels, please approach.
Oh, Father.
Councils, please. We need to start. Council, you're okay? Good evening. Now, let's proceed. Now, having heard all the preliminary objection made by the defendants before this court, and also having heard the submissions made by the prosecution's team, it's in our view that in the best interest of the child that we find that this court is close to the jurisdiction, and therefore we will proceed to hear this matter as agreed between the parties before this court. Thank you. We will give each team 15 minutes for giving their submissions, and then they will also reserve 5 minutes for their rebuttals. So we'll start with the prosecution side to start their case.
May it please this honorable court. My name is Maranga Franklin, for the purposes of record again. This court has been seized with a matter in which a child NW having his place of residence being raided by the lower community. She is forcibly taken by the raiders and then subjected to confinement in the home of the raider for her to get married after 2 years down the line. The child we are talking about is 11 years old. Having laid that background, I'll be proceeding to demonstrate to this honorable court that the raiders particularly, just a minute. Particularly Nataim, who forcibly took NW from her parents, from the custody of her parents, and took her for the sake of forced marriage, performed an act which we call child trafficking. And I'll be seeking to rely on various provisions of the law to buttress the same. Of great importance is to start with the Children's Act, and Section 13 protects a child from all forms of exploitation, including cell trafficking or abduction by any person. So the Children's Act, which is a domestication of the Convention of the Rights of the Child, has guaranteed that protection. But to establish that child trafficking is a criminal matter, I will refer the court to the Counter Trafficking in Persons Act. Counter Trafficking in Persons Act, particularly 3, which proceeds to say that a person commits the offense of trafficking in person when the person either recruits, transports, transfers, or harbors or receives another person for the purposes of exploitation. And the recruitment, the transportation, the transferring, the harboring, or the receiving has been actuated through the use of force or forms of coercion, fraud, deception, or an abuse of a position of vulnerability. In this particular case, NW is forcibly taken by Nataim from the custody of his parent. So there is an aspect of the use of force. It is against the wish of the parents and against the wish of NW as a child. And number 2, he is transported because is taken from her place of residence and taken to the home of the raider, consent lack of consent notwithstanding. What are some of these forms of exploitation that the Act talks about? I will refer the court to Section 2 of the Counter Trafficking in Persons Act that speaks of exploitation to include, but not limited to, the language there is permissive, but I find whatever is necessary on what is listed. Among them is sexual exploitation, child marriages, or forced marriages. On that premise, NW having been taken from the custody of his parents, we get that at the attainment of 13 years, she's in the business of washing dishes and Nataine bounces on her and defiles her. That is sexual exploitation. And having reached that age of 13 years, she is also forcibly married to Nataine, which is a case of child marriage, and it is forced. So that qualifies as exploitation. Because there is an element of force and there is also coercion. Because when we are referring to matters children, even if they could provide, even if someone could argue that they gave implied consent, children have not reached the age of majority to be able to consent to such acts. Section 3.3 will tell you that the recruitment, the transportation, the transfer, and harboring of the children for the purposes of exploitation shall be considered trafficking in person, even if it does not involve any means that I have already enunciated above. So the protection of children against trafficking in person is highly protected by the same act. I will also finalize by asking this question: Can custom be an impediment? Can custom allow trafficking in person? The Constitution is very informative. Article 2.4 says that any law that is in any law, including customary law, that is inconsistent with this Constitution is null and void ab initio. Section 3.2 of the Judicature Act also says customary law can only be applied if it is not repugnant to justice and morality, and it is not inconsistent with any particular law. Is the custom of trafficking in person permissible in this community? They will argue yes, but does the Constitution and the counter trafficking in person allow for the same? The answer is no. And to that extent that customary law is inconsistent with the written law, which is the counter trafficking in person, then it is invalid, and that cannot be a ground to prejudice and to perform this inhumane treatment upon the child. So that is the establishment of the charge, and also we are also submitting that custom cannot suffice to expose children to such kind of measure. If there is no any question from the bench, I cede the floor to the next counsel.
Thank you very much, Your Lordship. I would first of all like to tackle the issue of FGM. The FGM Prohibition Act defines FGM, female genital mutilation, I will read in verbative, comprises all procedures involving partial or total removal of the female genitalia or other injury to the female genital organs or any harmful procedure to the female genitalia for non-medical reasons. So in this case, the minor was exposed to a harmful cultural practice, which is FGM, prohibited under the FGM Act as well as the Constitution of Kenya. The Constitution of Kenya, Article 2526, says that the ratified laws, the ratified international treaties form part of the Kenyan laws, and we see very many international instruments trying to protect the girl child and women from FGM, such as the CEDAW and the Maputo Protocol, which we committed to in order to protect the rights of women and girls from freedom of harmful cultural practices. And let this court take note that to mutilate simply means to destroy. And in this case, we can see that the minor was exposed to FGM. The Constitution recognizes the right to practice your culture. However, it has to be in line with the Constitution of Kenya. And in this case, this is a harmful cultural practice because it could result to overbleeding, which at the end might lead to death and also might cause infertility. For this offense, Your Honor, Section 20 also says that those who aid and abet in the procurement of female circumcision, in this case I will use female genital mutilation so that you can understand the gravity of this harmful cultural practice. And the co-accused are the one who escorted the minor to procure FGM. So in this case, Your Honor, I would also like this court to find them culpable of the same. On the issue of child marriage, on the issue of FGM as well, the Children Act under Section 14 protects children from the same. Allow me to read in verbatim. No person shall subject a child to female circumcision. That is literally the first part of this provision. That no person shall subject a child to female circumcision, regardless of custom. It is wrong against the law and against humanity. It is a grave misconduct. On the issue of child marriages, in Kenya, the minimum age for one to get married is established under Section 4 of the Marriage Act, which is 18 years old. It states that a person shall not marry unless that person has attained the age of 18 years. In this case, the minor was trafficked, or rather kidnapped, when she was 11, and by the time that the accused claimed that he wanted to marry the minor was 13 years old. So in this case, she is still not eligible for marriage, despite whatever their custom says. Again, I will state that the Constitution provides that any cultural practice must be consistent with the Constitution. The Children Act, also under Section 14, states very well that no person shall subject a child to female circumcision, early marriage, or other cultural rites. All cultural rights are outlawed. All harmful cultural practices that constitute cultural rights are outlawed by the Children Act under Section 14. So in this case, Your Honor, the accused claims that they can marry once the child has transitioned into adulthood. First of all, the right of passage or the right of transition is initially wrong according to the law, and therefore this is a violation of the child's right under the Children's Act and under the Constitution as well. On the matter of child labor, the Children Act under Section 10 defines child labor. First of all, it's a provision of protection from child labor. Every child shall be protected from economic exploitation and any work that is likely to be hazardous or to interfere with the child's education. In this situation, Your Honor, the minor did not attend school, and if anything, the laws provide that children have a duty and responsibility towards their parent. However, these only constitute light work. Light work is that which does not interfere with the child's play, the child's development, mental, physical, psychological development. And most importantly, it should not interfere with the child's education. In this case, the minor did not attend school. The International Labour Organization states very well that child labor is any work that deprives children of their childhood. And as you can see clearly, the minor was building fences and really did not have time to play. She was in between building fences and working on the farm. Clearly, this is a violation of this child's rights. And the minimum age convention also states very well that...
Counsel, before you proceed, I take note of your trail of thought with respect to allegations of child labor. You in your application part of your submission, you talked about the child helping, because as will be read from, I think, paragraph 4, that's the second line, that he did not he did not take her to school, and instead he made MW work on the farm, in the homestead, as well as making sure that he, MW, assisted the laborers. Does that constitute child labor? And if so, what then could be the test to child labor? More importantly, you also talked about education. Yes, we concede that we understand that the actions, the proposed house calls, I will be read from again paragraph, the last paragraph, where, no, not the last paragraph, the second last paragraph. They are called house calls. Do those actions fall under house calls? And if they do, deterring the child from attending education, does that violate the right to education, or does that constitute in itself child labor?
So in this case, I will first of all start with the last concern. In this case, the child's right to education has been violated, and I'm also using that as an indicator of child labor, such that any work that interferes with the education of the child constitutes child labor. Then clearly, on the matters of assisting contracted laborers, these are professionals working together with an 11-year-old, Your Honor. That is clearly a violation of this child's right. This child is being exploited, because you can see clearly the contracted laborers, by the term contracted, simply means that they're getting paid. But this 11-year-old inexperienced little girl is also working the same job, performing the same duties as contracted professionals. That is very hazardous to the child's health, in fact, and therefore constitutes child labor.
Thank you, Counsel. How many points do you have? How many issues are you still addressing?
I'm addressing FGM, child labor, and child marriage.
Could you take, because your colleague, if say she wants to address, could you just give us a brief of what the next issue, because we've gathered the point on child marriage and child labor. So could you address us to the last issue you mentioned, that the one you've not...
Of FGM?
You've talked about FGM, child labor, and marriage.
Yes, my colleague will handle the last one very briefly.
Counsel, 3 minutes is enough? All right.
Much obliged, Your Honor.
Much obliged, Your Honor. I must indeed remark that I'm truly humbled to appear before this honorable court in such a matter which is so grievous as to discuss and to protect the rights of the child. So I'll take 3 minutes just as you've allocated me, and I'm going to discuss the last issue, which is with regards to the defilement of the child, and then link it to the same, preventing the child's right to the highest attainable health and her dignity, respectively. So, I do not to go into the...
For purposes records.
For purposes of record, once again, Your Honor, Odora Buta for the petitioner. Yes, so you are able not to go into the details of proving the elements of the offense of defilement, as this is a case of what we do call res ipsa, since the child in this case, NW, is pregnant, and we need not to dive much into the issue of penetration and other issues. She's a minor, definitely, so defilement is proven. We need not to go into that discussion. So I'm going to link it to the right of highest attainable health and dignity respectively. So the state of Liwawa ascribes to the international conventions such as the CRC, the UDHR, ICESR, via Article 2.5 and 2.6 of the Constitution. And so these international conventions do apply to them. Your Honor, the WHO, via its Constitution of 1945, has clarified that the right to highest attainable health does not merely constitute freedom from disease, but goes further to encompass more than just that, as it also includes a complete physical, mental, and social well-being. So in that same vein, Honorable Bench, I do submit that the act of Nataim of subjecting NW, a child, to defilement does contravene the rights of the minor as protected in the various international bill of rights instruments, among them UDHR via Article 25, the same with the International Covenant on Economic and Social and Cultural Rights via Article 12, CRC does the same via Article 24. Yes, and the very own Constitution of the State of Liwawa via Article 43(1)(a) also safeguards against such, stating that every person has the right to the highest attainable standard of health, which includes the right to healthcare services, including reproductive healthcare. So just to wind up, Honorable Bench, I do submit that indeed the act of Nataim of subjecting the child NW to defilement does contravene the same right to the highest attainable standard of health and dignity. Thank you.
Council, before you sit down, just a quick clarification. Please restate the laws that you've relied on concerning the health of the child that you've just mentioned.
Thank you, my lady. I've referred to the very first one, Article 25 of the UDHR, which introduced the issue of the right to the highest attainable health and dignity. The second one, I relied on the 1966 ICESCR, International Covenant on Economic, Social, and Cultural Rights. It's Article 12. Then I relied on the CRC, that's the Convention on the Rights of the Child, Article 24, which underpins the same right to highest attainable health and dignity. Then I also referred to the WHO Constitution, which basically gave a clarification on what this right entails, stating that it's a complete physical, mental, and social well-being, moving away from the traditional notion that the right to highest attainable health and dignity simply meant that you are free from diseases and illnesses. So currently it's a wholesome encompassment, like complete physical, mental, social, emotional well-being. That's why I refer to the WHO Constitution. And also for further clarification, Honorable Bench, the general comment number 14 gives the scope of what the right to highest attainable standard of health needs to entail, and it includes the emotional, physical, and social well-being. Unless there is any other question, I cede the floor to my lead counsel.
Thank you, Counsel. That is all. You may have your seat.
Thank you, Honorable Bench.
So for the purpose of record, I'm Counsel Kereu Benjamin. I'm the counsel for the defendant. Therefore, firstly, before I start to tackle on our defense, on our issues that we are to raise, the prosecution has touched on very pertinent issues that we like to bring the court to note on them. The first issue is on defilement. They have said that since the victim was pregnant, it is res ipsa loquitur that our client is guilty of defilement. I know they are akin to Section 8.1 of the Sexual Offences Act. The section is very clear on the elements of defilement. It is causing penetration with a child. Therefore, telling us pregnancy to prove defilement and there's no even DNA reports is very malicious, in fact, very defamatory to our client. Therefore, they have to prove that element. They can't just rely on pregnancy to prove it.
Counsel?
Yes.
With reference to paragraph 4 of the facts, I think the last, the third last line, maybe I'll give you the substance. Maybe we would want to presume as the bench that the drafters of the plaint or the facts to this petition did not want to take us through down the trail of what happened, but they simply stated that the accused defiled. It is prima facie on the fact sheet that he defiled. Do we still need to prove, yet it is stated that he defiled? You know, it would have been a different case if the facts would have said maybe he went, he touched, he would have given the trail of those. So kindly address that.
Okay, to address on that issue, actually we were ready to proceed as respondents. Then we were told now it is a criminal case. And you know, in a criminal case, there's the golden thread in criminal law of presumption of innocence. And you must be tried in an open court based on our Bill of Rights. And it should be a trial, complete trial to prove elements of a crime. That's a golden thread in our criminal system. Therefore, the reason why, but okay, it was just a rebut on that issue. That's not the main issue. Then let's proceed. Another issue was the issue of building fences, as quoted by my fellow counsel. Actually, I'm glad the bench pointed out the child never built fences, assisted in the building of fences. So those are two different things. Let me now allude where I put this rebutting on. Child labor is the issue I'm going to tackle.
Counsel, you're saying the child assisted.
Yes.
Did the child volunteer to do so? Was she forced to do so? And then also, because you've raised the issue, could you kindly talk to us about Article 10 of the Constitution, Section 4.1 and 53 of the Employment Act as well? Article 30, not 10. Article 30, Section 4. Article 30 of the Constitution, Section 4.1, Section 4, subsection 1, and Section 53, subsection 1 of the Employment Act. If, with regards to whatever you've said, the child assisted, or what do you understand by the term assisted?
Okay, to answer that question, as my fellow counsels are checking up on those laws, as I don't have them here, I'll start with the issue of Article 30 of the Constitution of Kenya. Article 30 of the Constitution of Kenya reads that a person shall not be held in slavery or servitude. A person shall not be required to perform forced labor. Then I read that article with the Children's Act, Section 21 of the Children's Act. My co-counsel can help me read that in verbatim. I don't have it here. Section 21 of the Children's Act talks about the duties and responsibilities of a child in a homestead. So as much as the Constitution, actually it is good I could have Section 21.
Duties and responsibilities of a child. in the application of the provisions of this Act and in any matter before a court of law concerning any child, due regard shall be had to the duties and responsibilities of a child to work for the cohesion of the family. Then, B, respect his parents, superiors, and elders at all times and assist them in case of need.
Just when you want to respond to that question, was this child home? Was the child home? Or what do you mean by a homestead? Can you define to us a homestead in line of the case before us?
Actually, before our team proceeds, we have spent 5 minutes to answer questions, and
We've noted
the bench
that.
will note that.
We will
Thank
take
you.
judicial notice of the
Thank
same.
you. So let me proceed to that. You have asked about homestead. But before I come to a homestead, let me put these facts in context. The protection of children regime internationally, there are laws. There's the Convention on the Rights of a Child, which were drafted not in Africa. They were drafted in the Western. That's why when the African countries got independence, they thought that we have to put a charter in place that reflects our diversity. Therefore, on the promulgation or the drafting of that charter on the rights and welfare of the child, which was drafted by the Organization of the African Union, the presidents of Africa and people went there from the various cultures of Africa. They thought that in African culture, a child should work. Actually, that's how we have all grown here. The issue of not working is a Western concept. Assisting with the chores of the family is a basic tenet of the African self. It's our identity. Every child here, every day when they wake up, they don't do work voluntarily. Sometimes.
Counsel.
Yes?
I want to take you to a journey, but this journey will be a very short one. And I'm taking you to the preamble of our constitution. It talks about we, the people of Kenya. What does that tell you? We, the people of Kenya. And you read that preamble of the constitution in line of Article 2, Sub-Article 5 and 6 of the constitution. What does it inform you about international laws and the convention that Kenya has ratified?
Okay. So we, the people of Kenya, I should explain what that explains to me. We, the people of Kenya. So I feel that this constitution comes from us, the people, because we voted for it in a referendum. That's why there's this poetic nature of we, the people of Kenya, in the preamble, which the drafters so that it should carry should explain that the people voted for it. It's a referendum. So we gave this constitution to us. Therefore, you have asked a very...
It's ours, and we are bound by it. And even Article 10, we are supposed to uphold it at all times.
Yeah, we are bound by it.
Yes. Then, even we've ratified the international laws into our laws. So we are supposed to be bound by them as well, according to your reading. So what do you mean by these drafters, the statement you made, these laws, international laws that we have African nature? What do you mean by that?
Actually, you are raising a very...
It's you who raised the issue, Counsel.
Oh, okay. There's a very critical debate of dualism and monism and the issue of domestication of laws. And I guess, based on the legislative jurisdiction of a country, the way it has domesticated its law is the way it wants it to apply in its jurisdiction. That's why the drafters of the Children's Act, Section 21, they looked at the Kenyan circumstances, coupled them with the international practices and our responsibilities under the international conventions, and so that this Section 21 doesn't actually contravene them. It just complements them based on our diversity.
Okay, Counsel, proceed to your issues.
Thank you.
How many issues are you addressing?
I'm addressing just one, then my
Kindly
fellow one is three issues.
Finalize on your issue then.
Yeah, so we'll make sure we are as brief as we can. Okay, so I'm going to tackle on the issue of child labor. Child labor will be my first issue. So I'm going to rely
Have you
on
not addressed us to that? Because the questions we were asking, you can proceed to the next issue because we are satisfied with your submissions on the child labor.
Actually, I was just tackling on one issue, then move on. Yeah, time. We entirely with the bench, they agreed to add equitable time based on questions. Okay, much obliged, Your Honor. So on the issue of child labor, the Act says that child labor refers to any situation where a child provides labor in exchange for payment. And actually, the payment was our main issue there. And we can see that this child was providing labor in an African home for cohesion of family. He was just helping. Therefore, this cannot be said to be a child labor issue because there is no exploitation. When they say that there was no school attendance, they're only referring to education in the formal sector. My team and I recognize that education can be informal and apprenticeship is education. Therefore, if this child was being exposed to education at home, take due note that these are pastoralist community and they cannot take a child to a school that is not there. Therefore, saying that the child was not taken to a school as a form of defending the fact that this was child labor will be wrong precision of facts. So that's the issue of child labor. So we hold that NW was not exposed to child labor. Then another issue I'll talk about before I leave here due to the import of time that is not there is the issue of customary law. The position of customary law, because if you look at these issues, they're trying to juxtapose our customs with the legislated law. That's statute law. So I'm going to talk about the issue of customary law and the position of customary law. We understand that the Judicature Act the Judicature Act, Section 3.2, has placed our customary law the lowest in the rank of laws. We are aware of that. We take note as the defense team. We also take note of Article 159.3 of the Constitution that recognizes that our dispute resolution should be subjected to the repugnancy test. We are aware of all those. But now we want to indulge this court on the discussion of customary law. Why is our customs as Africans changed all of a sudden after colonialism? When you look at the issue of
Counsel, I think you're dividing from what has brought before this court.
yes.
I think the issues you're going into the academic realm that we will leave for other people to do. For us, we are here for a specific duty. Yeah. Maybe if you're done with your submissions, we can allow your colleague to come.
Actually, before my colleague comes,
Counsel, your 2 minutes are dispensed. So we will
please let me ask the lenience of the bench because we have not expressed our issue, the main issue.
We are satisfied with your issues. We allowed you 2 minutes, which have already been dispensed with. Yeah.
Much obliged.
Thank you.
For the purposes of record, Counsel Brian Mutai, and I'm going to be tackling the issue of early marriage. And in recognition of that this is a pastoralist community, and it is among the community that it is marginalized, and it is the minority community. The Kenyan constitution the Kenyan laws under the constitution, Article 2, 5, and 6 provides for the domestication of international laws. And under that, we look at the UDHR, which provides for the provision of the fundamental freedoms and rights of all individuals. And these rights, this provision include the recognition of the rights of the indigenous groups, which in this case is this community. And this recognition of rights involves the recognition of their customs and their way of life. So the question of early marriage in this case is that this is part of their customs, and in fact, in their traditions, when you attain the age of 13, that is when one has attained the puberty stage, they are subject to marriage, and they are subject to marriage. So the issue of early marriage in this community and the provision of the laws under the UDHR, which recognizes the practice and the customs of the indigenous community, we therefore submit to this.
Counsel, before you proceed, you've talked about the age of 13 being considered as acceptable in marriage. Kindly provide the basis for this in terms of law or even case law, or if you have a customary law that you're relying on, please provide to this court.
In this, we were relying on the provisions in the UDHR, which guarantees for the protection of fundamental freedoms and rights, which includes the protection of the customs and the way of life of the indigenous groups, and in this case it's the pastoralist groups. And this practice of their custom is part of their way of life, whereby their timelines for marriage and the guideline is after the attainment of puberty stage, that is adolescence.
Yes, we hear you. However, I want you to read for us Article 45, Sub-Article 2 of the Constitution, and also discuss to us or tell us what is the hierarchy of laws when it comes to applicability of laws in Kenya, in Malawi. What is the state? Malawi. Wilawa. What is the applicable law when it comes to the state, the hierarchy of laws? And in line of reading of Article, I can read for you Article 4, Article 45, Sub-Article 2. Every adult has the right to marry a person of the opposite sex based on free consent of the parties, an adult. And the Children's Act, maybe, and your colleagues have referenced to it vehemently with regards to definition of who is a child, to your understanding, and then what is the applicable law in terms of hierarchy of laws. Do you want this court to take the UDHR position, or we take the constitutional position?
The position of laws is that the Constitution is the supreme law of the land.
Does that inform your statements? What do we make of your statements?
Yes.
What do you want this court to make of the statements you've made about the UDHR allowing customary?
The same Constitution under Article 2, 5, and 6 allows for the domestication of the international laws, which in this case now we are using the UDHR.
Okay, counsel, proceed to your next argument.
The next issue.
All right, thank you, counsel.
Purpose of record again, Counsel Nkai Solomon for the defense. My
Counsel, before you proceed, because your time is spent, we'll add you 3 minutes only. We'll give you your team 3 minutes.
Most obliged.
Yeah.
My issue is only one, and I think even 3 minutes will be sufficient to tackle the right. The question here is, does the act of FGM limit the right to attainable health of the child NW? And it is our considered position that the right of the child was not in any manner violated. We are privy to the fact that the Constitution of Kenya and also the Health Act, Section 5.1, gives every person a right to health, which is the highest attainable standards of health. The FGM Act, it is our considered view that if the FGM Act, upon its enactment, came to limit the women's right to choice and the right of minorities to their culture and ethnicity and even identity. And therefore, saying that FGM is wrong in its own manner is discriminatory to the people of Lewa, and we are very unfortunate for that.
Council, I understand your statements and sentiments to be leading to a conclusion that you're blaming the promulgators of the FGM Act.
Yes, I think it is.
That's in order. But at the same time, are you not the state who oversaw the promulgation of those laws?
Your Honor, I think the bench, this is an high court, and through your decision today, you can rule this act to be unconstitutional, null and void, for it infringing the rights
Counsel.
of undiscriminating people of Lewa.
Counsel,
Yes.
Was that part of your pleadings when you came to court? Was it part of your prayers? So can you stick to what has brought before this court?
Thank you. Just to wrap up on what we are submitting. Just to wrap up on what I was submitting. Having said that FGM and FGM, they have tried to paint it in a wrong manner, and it is our view that FGM acts to limit pregnancies and also to give security to these young women, because the act does not, the law does not force the young men of Lewa to marry these women who are circumcised. In fact, this girl, if she was not circumcised, then the boys and the men of this community will have shamed her and will have brought her dignity down. And therefore, the act of circumcising her was cleansing her and making her marriageable, and making her to get a family. And therefore, we are continuing families here. Thank you.
Thank you, counsels. We really appreciate your
Does the bench have
submissions.
any questions?
No, we do not.
Thank you.
Okay, thank you. I don't know if, do you have rebuttals? 1 minute? Okay, 2 minutes. 2 minutes maximum.
To the honorable bench, I'll just do a quick rejoinder.
I'll start from the premise of whoever comes to